Hello, everybody. So, this little screencast is about Marbury versus Madison and institution of judicial review. And it's important in and of itself, but it should help you with the trial that we're working on in class. First of all, who is John Adams? John Adams is a patriot. He's the second president of the United States. He's a Federalist. I'm not sure if that got cut off or not. And he is a loser. Haha. Yes, he is a loser. He lost the election of 1800. And him losing the election of 1800 is going to set into motion a chain of events that will eventually lead to the Supreme Court case known as Marbury versus Madison. When you lose the presidential election, there is this period between when you lost the election and when the new president takes over, in which you are referred to as a lame duck. It's normally a period where the losing president does not get a lot of support, cannot really do a lot of things, doesn't have a mandate from the people. During this lame duck period for John Adams is going to appoint a number of people to prominent and important positions. These appointments are called midnight appointments. Now, they're not literally made at midnight, but the idea is they're the appointments that are made in the last months of John Adams's presidency. Why would John Adams make so many appointments to these positions before he leaves? What was Adams afraid of? This happens to be one of my favorite political cartoons, Mad Tom in a Rage, and I realize the screencast might not catch all of this, but you get the idea. And, you know, the first time you've seen this cartoon, you might be taken aback and not exactly know what's going on. Obviously, you see the devil here and Thomas Jefferson, and not only Thomas Jefferson with the devil, but drinking brandy as he does it. But more telling about the fear that Federalists had of Thomas Jefferson was, what was Thomas Jefferson going to do? Is he going to, as this cartoon illustrates, rip down the pillars of government? Thomas Jefferson, who believed in strong state government, who was opposed to things like the use of the Alaska Clause. There were a lot of people who had real fear about what Thomas Jefferson would do. So John Adams tried to fill positions with Federalists who could work against the radical ideas of Thomas Jefferson. As we're going to find out, Thomas Jefferson was nowhere near as radical as many had feared. But that's not going to stop John Adams from giving jobs to people who he think see government the way his vision of government is. This leads us to Marbury. No, not Marbury the point guard, but William Marbury. Someone who, other than this case, would probably not have gone down in history as being all that important. He was supposed to get a fairly small, in terms of the history of the United States, position as the judge of the District of Washington, D.C. This is not that important, but it's just the position that he was waiting for. When you get appointed to something, you get an official appointment. And that official appointment needs to be signed, it needs to be sealed, and it needs to be delivered. Marbury's appointment, in the confusion of the midnight appointments, all of these appointments going out, was never delivered. So when Jefferson comes into town, I write a new boss in town, Jefferson does not want to deliver the appointment. He doesn't like the fact that John Adams had already filled so many positions with Federalists. He doesn't personally like Marbury very much, and he doesn't give him the appointment. What Jefferson does do is Jefferson doesn't want to be embroiled in any case. So he actually gives it to his Secretary of State, James Madison, and orders James Madison not to deliver the appointment. This is why the court case is called Marbury versus Madison. And even though this court case is called Marbury versus Madison, I think what we're going to see is that this court case is really Jefferson versus John Marshall, the Chief Justice of the Supreme Court. This is an example of two brilliant men doing battle over the interpretation of the Constitution. All right, so some of the details of the case. Now, I don't want to get into too much details because it can bog us down and it can distract us from what's really important. But when you sue someone, you can't just sue someone because they're wrong. You know, it can't be something vague like, that's wrong, I should have gotten that job. You have to sue someone based on law. And ideally, you have to sue someone based on a specific law. And the specific law that Marbury was suing, had his suit based on, was the Judiciary Act of 1789. Now, 1789 is the same year that the Constitution goes into effect. So this was one of the first laws that was passed. And the Judiciary Act of 1789 said that the Supreme Court could handle issues like this. Like if there's ever an issue about who gets an appointment as a judge, the Supreme Court can issue something called a writ of mandamus that would force the executive branch to deliver the appointment. So essentially what Marbury was asking for was a writ of mandamus. So force Jefferson to give me my job, Supreme Court. And the reason that you're allowed to force Jefferson to give me my job is because of this Judiciary Act of 1789. Now, who was the Chief Justice of the Supreme Court? The Chief Justice of the Supreme Court was John Marshall. John Marshall is intimately involved in this whole situation. Who's John Marshall? He's a leading Federalist. He is the Supreme Court Chief Justice. It's interesting to note that most people think John Marshall was the first Supreme Court Chief Justice. He wasn't. He was actually the fourth Chief Justice of the Supreme Court. But he's the first one who actually used the Supreme Court in a way that we would recognize today. And it all has to do with this court case. So that's why he's so notable in terms of the Supreme Court. Now here's where it gets really interesting. He was actually part of those midnight appointments that John Adams made. He was recently appointed to the Supreme Court. And on top of everything, he was cousins with Jefferson, but the two had a real personal animosity towards each other. And as if all of this stuff isn't enough to intimately connect John Marshall to this case, he was actually the Secretary of State who did not, and I know that this might be cut off on your screen, who did not deliver the appointment in the first place. So he was the Secretary of State when John Adams wanted to appoint Marbury to the position of judge. And it was his office, I mean, he wasn't supposed to hand deliver it, but it was his office that did not deliver the appointment. So the connection here is just fascinating. It gives you an idea of what Marshall wanted to do. Now, here's where we pause, because here are two great minds, and they're doing battle here. Jefferson sees this as a win-win. If he wins the case, and if John Marshall says, no, Marbury, I'm sorry, you don't get your job, Jefferson wins. But what if Jefferson loses the case? What if Marshall says, Jefferson, you must give Marbury the job? And Jefferson could then just ignore Marshall. You have to realize that this is early in American history. Precedents were still being set. Can the Supreme Court tell the president what to do? What if the Supreme Court doesn't? What if the president doesn't listen? Jefferson was very popular. Would Marshall have any way to force the president to do or to follow his decision? So Jefferson felt that if this were a chess match, that he had Marshall trapped, that anything that Marshall did, he would be able to counter. Marshall institutes one of the most famous, one of the most important decisions in American history, arguably the most important Supreme Court decision ever, when he says, Marbury, now I say, what did Marshall want to do? Marshall's a Federalist. He probably wanted to give Marbury the job. He wanted to help out his fellow Federalists. But what Marshall does is even more brilliant. He says, Marbury, I'm going to go back here. I'm going to go back very quickly. He says, Marbury, I'd love to give you the job, but the Judiciary Act of 1789, the law that says I can give you the job, that law is unconstitutional. The Supreme Court does not have the power to handle these issues regarding, jobs and judges. The Supreme Court has the power to declare laws unconstitutional. And that is what I'm doing now, Marshall says. I am declaring the Judiciary Act of 1789 to be unconstitutional. Congratulations, Jefferson. You win. Marbury doesn't get the job. But in winning, Marshall illustrated or exercised the most important power that the Supreme Court could have, which is declaring laws unconstitutional. What makes this, even more interesting is that earlier in American history, Jefferson had argued that it's states, through the famous Virginia and Kentucky resolutions, that it's states that have the power to declare laws unconstitutional. So Marshall really, obviously, went against that. As a Federalist, he believes in a strong federal government, the Supreme Court being a part of the federal government, that Marshall says it's the federal government that has that power. Now, I'll zip right through here. What could Jefferson do? Could Jefferson say, wait a minute, no, I don't like that I won? His hands were tied. So you have two brilliant men here who are doing intellectual battle, and John Marshall got the better of Thomas Jefferson. He declares the Judiciary Act of 1789 to be unconstitutional, and this is just a few notes on it. And in the loss, he empowers the Supreme Court. He establishes the precedent in such a way that Thomas Jefferson cannot refute it, can't go against it. And by establishing that precedent, he established one of the most important precedents in American history, and that's the precedent of judicial review. Judicial review is the power of the Supreme Court to declare laws unconstitutional. Now, just a few more minutes here. As Marshall is in the Supreme Court, the Federalist Party dies. The Federalist Party is not around anymore. And Marshall gets one of my favorite nicknames, and get ready, this is a little corny. Marshall becomes called the Ghost. Oh, that's scary. He becomes known as the Ghost of the Federalist Party because, one more time, the Ghost of the Federalist Party, because although the Federalist Party is no longer in power, although the Federalist Party is no longer in existence, John Marshall is going to issue decision after decision that is reminiscent of the Federalist Party and what the Federalist Party stood for. So you see decisions that bolster a strong government, decisions that are pro-business. The court is insulated from public opinion. A Federalist could never win office, after the War of 1812, after 1816, the Federalist Party is no more. But John Marshall is insulated from that change in public opinion, and he's able to issue decision after decision that strengthens the original ideas of the Federalist Party. That's why John Marshall is called the Ghost of the Federalist Party, and I like doing that. This decision created the idea of judicial review, and that is a summary of Marbury versus Madison. For those of you who are watching this presentation to help you with the trial that we're working on in class, Marshall is a particularly important person in this trial because of his interpretation of the Constitution, his relationship, politically anyway, with Thomas Jefferson, how he refuted Jefferson's Virginia and Kentucky resolution, and not to mention all of the connections that he has with John Adams, not only as the Secretary of State, but also as one of the ambassadors that was part of the XYZ affair. So I hope this helps, and I will see you all in class.